Good afternoon, everybody. My name is Nigel Nordone. I'm the head of tax at Qdos. And this afternoon, we're doing the second in our technical series, IR35 technical series, in respect of overseas arrangements. Some of you may have already been on the first session that we did this morning on personal service, aka the right of substitution. In this session today, we're going to talk about overseas clients, offshore agencies, and non-UK contractors. One of the most common queries we've been asked over the last 12, 18 months about the off-payroll rules is around what happens if the contractor, fee payer or client are based overseas. And up until pretty recently, the legislation has been frustratingly unclear in most scenarios. So we're going to go through how the rules work, i.e. who's responsible for determining IR35 status and when it might not apply and when a party in the contractual chain is overseas. So overseas clients, so let's look at these. In a straightforward scenario where all parties and services are in the UK from 6th of April 2021, it will be the responsibility of the end user to determine the IR35 status of their contract workers. The fee payer, the party who directly pays the PSC, which is usually a recruitment agency, but can be another third party, or the end user if direct, is then responsible for deducting the relevant tax. Obviously, there's rules around this in respect of these businesses have to be classed as medium or large, but we'll cover that in the sessions that we'll do in the future. So in a typical scenario, you have the end user, which is the client, and it's the end user's responsibility to determine the IR35 status of the PSC worker. The status decision is then passed to the fee payer and to the PSC, and it's the fee payer who deducts any relevant tax if the status decision means that the client, the contractor is inside of IR35 or their limited company is. So what happens where the end user is wholly overseas? And surprisingly, and it is surprisingly, because it's HMRC, the rules are actually very clear where the end user is based wholly overseas. In this case, the rules state that the off-payroll rules do not apply. The end client does not need to determine IR35 status, and the responsibility for determining the IR35 status is passed back to the contractor. So for all intents and purposes, post 6th of April 2021, if the end client is fully overseas, then the limited company contractor will determine their own employment status as they do today under the current IR35 rules. So where the end user is wholly overseas. A business will not be classed as wholly overseas if either of the following apply. Either a UK resident incorporated in the UK with certain exceptions, or the central management and control of its businesses in the UK, or have a UK permanent establishment. Fixed place of business, e.g. a branch, office or factory. An agent has habitually exercised authority to do business on behalf of the client. A company can also reference individuals, not companies. So for a company to be considered wholly overseas for the purposes of off-payroll rules, a company must not be UK resident nor have a UK permanent establishment. Residency tests are highly complex and not our area of expertise, but as a general overview, the company would be UK resident if it's incorporated in the UK or the central management and control of its businesses in the UK. As defined in the Corporation Taxes Act 2010, a permanent establishment includes a fixed place of business such as a branch, office or a factory, and a permanent establishment can also be described as any agent who has authority to do business on behalf of the client. For the purpose of the reform, the reference to company in the Corporation Taxes Act should be read as a reference to individuals that are not companies. So where the end user is not wholly overseas, HMRC will pursue debt through the UK permanent establishment where an overseas client does not meet their obligations under the off-payroll rules. If you're an overseas client but do not meet these criteria and are therefore not wholly overseas, your business will still be responsible for determining the IR35 status of your UK resident contractors and issuing status determination statements, i.e. the off-payroll rules will apply. If the business does not meet their obligations, it will, as a consequence, be liable for tax and NICs where the rules apply, and HMRC will pursue this debt through the company's UK permanent establishment. So essentially, if you are company that has some permanent establishment within the UK and not classed as wholly overseas, you then will have the responsibility to determine the IR35 status of the contractors that you engage directly or via an agency. So where the end user is wholly overseas, where the end client is based wholly overseas, the contract responsible for the IR35 status regardless of the contractual chain. Often, however, there'll be another party in the chain, such as a UK recruitment agency, who will be the fee payer. The public sector guidelines stated that the liability moves to the next person in the contractual chain who is in the UK, which would be the agency in this example. However, further clarification provided earlier this year for the private sector rules means that from April 2021, where the client is based wholly overseas, the responsibility is that of the PSC contractor, and no other party need consider the rules regardless of that contractual chain. Everything hinges on the end user. So if you're an agency in a contractual chain with a client who's based wholly overseas, you will not need to consider IR35. So offshore agencies. Now let's look now when there is another party in the supply chain who is overseas. Another element of the off-payroll rules to consider is the transfer of the status determination statement from the client to the fee payer. In more complex contractual chains, the next party in the supply chain may not necessarily be the fee payer. In these circumstances, it is the responsibility of that party to pass the SDS down the supply chain until it reaches the fee-paying entity. The responsibility and liability of paying the appropriate taxes to HMRC also passes down the chain along with the SDS. So if the fee payer never receives an SDS from the party above it, it cannot be held liable. But what happens if one of those suppliers is offshore? Where there is an offshore agency in the supply chain. Where there's an offshore agency in the chain, it is the responsibility of the UK parties to ensure the process is followed. In this example, an offshore agency sits in the middle of a contractual chain. The first UK agency will be responsible and liable until the offshore agency passes the SDS to the next UK agency. In other words, the first UK agency will need to ensure the next UK agency receives the status determination statement. Simply passing the SDS to the offshore agency next in the chain will not remove responsibility away from it. The offshore party will not take any responsibilities under the off-payroll rules. So in this chain here, you can see the last UK entity is responsible for getting the SDS to the next UK entity. So you have the end user, the client, who makes the status decision. They then pass that status decision down to agency one, but clearly agency one, there'll be no point for them passing it on to agency two in the hope that agency two will pass the SDS down to the next agency in the chain, because that agency is wholly overseas. So it still remains the responsibility of agency one until they discharge their responsibility by making sure that the fee payer, the agency closest to the limited company contractor, receives the status determination statement. So what then if the fee payer themselves is in fact overseas? The rules state that where the fee payer is offshore, as in the previous slide, the last UK party in the chain before the PSC will be responsible for the deduction of tax and NIC contributions and paying these to HMRC. The offshore party does not take on any responsibility under the off-payroll rules. If the end user was in fact the last UK entity, i.e. you remove the agency one from this example, then the end user would become responsible for ensuring the appropriate tax and NI is paid to the HMRC. So essentially, if there's an offshore party within the contractual chain and they are wholly offshore and therefore not liable to UK taxes, they essentially, you can ignore them within the chain or assume that then, for tax purposes, for HMRC purposes, they don't exist. So therefore in this chain here, the client will pass the SDS to agency one, and agency one will then become the fee payer because the next agency before the limited company contractor is wholly overseas. So the responsibility rests with agency one. So what factors do you need to consider? So what does a contractual chain look like? Where do you sit within the contractual chain? What are your obligations as part of that contractual chain? I mean, ultimately, every party within the contractual chain needs to be aware of what the contractual chain is, because they need to know where their responsibility lies and whether they are responsible for issuing a status determination statement or whether they're responsible for being the fee payer. As you can see, particularly for agencies and more complex chains, things can get a little complicated. It is important, therefore, that you have a grasp on the contractual chains you're a part of, where you sit in them, and what your obligations are as part of those chains. Because sadly, HMRC will not accept ignorance as an excuse, or I didn't know, because HMRC will only look at what they would expect you to know, what information they would expect you to have gathered, what information they expect you to have, and they will make any decisions regarding liabilities, etc., and whether someone has or has not taken reasonable care in their view based on the actions that you have taken. So what happens if the contractors are non-UK based? So what happens with the contractors who are providing services overseas or non-UK contractors providing services in the UK? IR35 may apply if the worker is a UK resident for tax purposes, regardless of where the services are provided or company is incorporated. It's important to remember that IR35 applies to the worker as opposed to where the limited company is incorporated. This means that if a worker is subject to UK tax and national insurance contributions, IR35 may apply, even if those services are provided overseas or their company is incorporated overseas. Whether a worker is liable to UK tax and national insurance is a residency issue, which we're not experts in. And so if you're unsure on this matter, we would encourage you to seek residency experts for their advice, because that's not advice that we can give. So where a UK resident worker provides services overseas. So where a UK resident contractor is providing the services overseas, in most cases, the off-payroll rules won't apply to national insurance, although there are some exceptions to this. However, the contractor will be liable for UK tax no matter where the services are provided. Because one thing we know for certain is that HMRC will want their tax, and they won't give up the tax easily. So where a non-UK PFD provides services in the UK. Where a non-UK resident contractor is providing a service in the UK, there is likely to still be a UK tax liability, and the off-payroll rules need to be considered. For national insurance, however, the contractor may not be subject to UK national insurance for the first 52 weeks or have a certificate of continuing liability for another country, in which case they are liable in their home country and not subject to UK national insurance. As I said, and we've touched on earlier, residency is not an area that we specialise in, and it's an incredibly complex area of tax. And so if you need advice in respect of someone's residency, you would need to speak to a residency expert. So thank you for listening. If you have any questions, please feel free to ask via our Q&A panel. Tomorrow I'll be covering statements of work and contracted out services, so please feel free to join me again for those. And I can see we've got some questions, and so that's the first question. Is that slide that says you might be contracting with a client in Ireland and doing the work in Ireland, but the client is a subsidiary in the UK, as many banks would have? That would be a nightmare and wholly counterintuitive. Yeah, I mean, the thing with IR35 and tax and the new rules that are coming in, as with most taxes, I'm sure most people agree, is there's nothing straightforward. There's very few areas that are black or white. It's lots and lots of shades of grey. Agency one in the UK may not know the full chain below them or have the legal right to establish that. So how the dickens are they supposed to make that work when there is an overseas agency in the chain? See, as I touched on a moment ago, HMRC don't class ignorance as a response. HMRC say it is you're obliged to know, you're obliged to find out where you sit within the contractual chain. And actually that is covered in the employment status manual. If you have a spare few days to wade through that, within the employment status manual, it will cover the fact that you need to understand where in the chain you as a business fit and what your responsibilities are. And so, like I said, HMRC will say, as they always do, the information is out there, you just need to find out. Next question is advice on, there is a contractor who's an American citizen based in the US, but working with a London office and being paid from the UK entity of a global company. Does IR35 apply? Again, you'd have to look at the residency rules. If somebody's classed as non-resident and not liable to UK tax, then the chances are IR35 wouldn't apply. But obviously, you need to look at their residency status because there's all sorts of double taxation treaties between us and numerous other countries. Where agency 1 is UK and agency 2 is offshore, and therefore agency 1 deducts tax and 9C, at what value is that? Agency 2 value or PSC value? It's the limited company value. It's UK tax, basically, whatever rate of tax the limited company contractor is due to pay. What happens when local taxes are applicable, e.g. in Belgium, when you go beyond? Again, we aren't residency experts, and we won't give residency advice or tax advice in respect of residency. But as I touched on earlier, many countries have double taxation policies. So it would be for the contractor to find out and get, or the engager to get the residency and taxation advice for whatever jurisdiction was applicable. What if a contractor is based outside UK and deemed to be inside IR35 by UK-based end user? Again, it's wherever the work's being carried out. So if they're carrying it out for a UK-based client, then the client says you're inside of IR35, then they're inside of IR35 for tax purposes. Reasonable care is a nonsense if you don't have the legal right to insist on knowing the full supply chain because of commercial confidentiality, etc. Plus, you don't know how much tax to deduct, as you don't know what they are being paid by the intermediary below you. Essentially, the tax that is deducted is at whatever rates the tax tables will tell you to be. So obviously, if somebody's earns enough that they would pay 40% on their salary, then on the income, then that's what you would tax them at. A fully offshore-based contractor who is resident and taxpayer of that offshore country, but is working a contract for the UK-based client as time and labour, with the TUCs between the UK agency and the UK client, can this be charged out at a service fee for the time and labour without needing to consider UK tax implications? Basically, a worker carrying on duties in the UK for an end client will normally fall within the scope of the UK charge to tax and be within the off-payroll working rules. There are some exceptions for non-UK residents visiting the UK briefly. But again, you would have to go to the employment status manual. And if anyone was of a mind to do that, I suggest you look at employment status manual 10025. Would you consider a company not wholly overseas if their parent company is based in the UK? Yes, essentially. It's if they've got a permanent establishment in this country, it classes them as a UK entity and subject to the off-payroll rules. Are HMRC expecting an overseas company engaged in a UK contract to get their UK office to provide an SDS for a piece of work done out of the country? Yeah, I mean, HMRC will expect that whichever part of the company is based in the UK to issue the SDS statement. Well, it could be the head office that isn't in the UK could issue the SDS statement, because what they will say is by having a permanent establishment within the UK, it means they're subject to the off-payroll rules. As to which part of the company issues that status determination statement, HMRC aren't going to mind, providing it's done and it's done with reasonable care. In the event that the client engages directly with a PSC, e.g. no agency involved, does the client still have to complete the SDS? Yes. It's always the client's responsibility to issue the SDS. In the case that's just been described, where the PSC engages directly with the client, not only would the client have to issue the SDS, they would also become the fee payer as well. They would be engager and fee payer, and therefore, if they issue an SDS that states the contractor is within IR35, they would have to deduct the tax as well. So reference to the last slide, for UK contractor working abroad for a foreign company, are you saying off-payroll rules won't apply, or are you saying that they might apply and is the PSC responsible for determining the status? If the end client is wholly overseas, no links to the UK whatsoever, and the limited company contractor is working for them, then it would be the limited company contractor who would determine their own status, because they could still be subject to the IR35 rules, subject to whatever their residency status is. Does it make a difference whether services are provided remotely from the UK or on-site in an EU country? No, again, it comes down to where the contractor, if it's a UK contractor, whether they're working abroad or not, they will be subject to the off-payroll rules, subject to their residency. But if they're a UK resident, they'd be subject to the off-payroll rules. Due to the complexity of some corporations, where can you accurately validate the client having a UK presence? My guess would be company's house. If it's a limited company, you would go there essentially. But that is purely a guess on my part. I really don't know, if I'm honest. Do I need an SDS in this chain? UK PSC, EU limited, UK agency, EU client. I'm last in the chain, or if I'm the only one to determine IR35 status, contractor resident UK, remote working for end client. I'm not sure from what you're saying whether you're the engager of the limited company, but essentially if the contractor is based in the UK and the client isn't wholly overseas, then yes, there will be an SDS statement needed. EU resident working in the home country engaged by a UK service integrator for a UK cost centre subject to IR35, yes. Can the agency provide the SDS for a UK contractor providing services in Europe if the UK branch of the overseas client doesn't want to know? The off-payroll rules apply to anybody who is UK based. So if you're the client and you've got a UK entity, you have to, and you're a medium to large business, then the off-payroll rules apply and you have to issue SDS. If you do not issue an SDS, then the liability stays with you until you do. Oh, somebody said, can I slow down when reading the questions? Sorry, I didn't realise I was going too quickly. If the agency is registered in Ireland, supplies a UK resident PSC to work in Germany for a client with no UK entity, does IR35 apply? If the contractor is working for a client wholly overseas, then it's up to the contractor to decide on their employment status. On the agency 1, agency 2 question, how would agency 1 know the PSC value in order to accurately deduct tax? Again, as I said, it's tax is deducted at the rates applicable within the tax tables. So personal allowance, then the 20% rate, and then up to 40 to 45. Our business works for the client in Germany. Our contractors are provided to that German client via a UK agency and a managing recruitment supplier. We're a global company with offices in the UK. Is our customer in Germany viewed as the end client under legislation? If you're sending contractors to a client, then the client who engages those contractors will be the end client. Yeah, so in that case, I would hazard a guess, without actually seeing the whole contractor chain, then that it would be the German. You're supplying contractors to them. You're acting as, if you like, an agency within the chain. So they would then be the engager. Yes. Is working outside the UK of itself not enough to take someone out of IR35? It would start again. It would all depend, try a different word, on their residency. Are they classed as a non-UK resident or not for tax purposes? So you would have to look into their residency status, and subject to whatever that was, would decide whether they were subject or not to the off-payroll rules. Somebody's asking me a general question from webinar 1. If the client makes an outside IR35 determination, as for example, they're receiving a service, is that the end of the matter, or does the intermediary agency have to do determinations themselves? No, when a client, and this applies to to IR35 off payroll from 2021, when the client issues a status determination statement and says that that contractor is operating outside of IR35 or inside of IR35, that's it. There's no need for any agency involved in the chain to make any further determination. They work on the determination issued by the end client, by the engager. Re your answer to my previous question, yes, but you have no way of insisting on being given some details of someone's tax situation and marginal rate if you're 1+ removed from them in their contractual chain. HMRC don't care, putting it bluntly. Essentially, if you pay a contractor £100,000, then you tax them at the rate that £100,000 would be taxed at. And then it's for the contractor then, when they submit their own self-assessment returns, to sort out any issues. In instances of a global client with HQ in Sweden, who have regional offices in each country, who have a contract of resource provision with a UK-based agency, who supply workers based in Ireland to work in Ireland, are they subject to IR35? If they have a establishment, an entity of the company within the UK, then they would be subject to the off-payroll rules. So is the work done where the worker is resident, even if it's physically done in another country? The off-payroll rules apply to UK residents. So if the contractor, limited company, is a UK resident, then the off-payroll rules will apply. So I've just read a point somebody's put through that essentially says, Tom Cruise will have problems with this Mission Impossible, typical HMRC, who asks you to do something that you might not be able to physically or legally do, but expect you to do it anyway, which, yeah, pretty much sums up HMRC, I'm afraid. I've got just time for one more question. Yeah, somebody's asked, and actually it is a good question. It's, can you confirm the definition of a medium to large companies? Yeah, this is taken from the Corporation Taxes Act, and essentially HMRC define a medium to large company as a company that can answer yes to 2 of these 3 criteria. An annual turnover of 10.2 million or more, a balance sheet total of 5.1 million more, and 50 or more employees. So if your business can answer yes to 2 of those 3 criteria, it would be classed by HMRC as being a medium to large business. So thank you everyone for listening, taking the time to sit through this webinar. As I said, we have 2 more tomorrow. One revolving around statement of work and one around contracted out services. So if you could join us for that, that would be great. So thank you very much for your time.